Everyone. Welcome to the webinar Platform Competition and Regulation, Navigating Innovation, Market Power and Dark Patterns. Our moderator for today is Ms. Bhumika Agarwal, Program Manager at Competition Law and Policy at The Dialogue, where her work focuses on competition law and AI policy. She has contributed extensively to research reports, white papers, and policy recommendations addressing key challenges in technology sector. With experience spanning e-commerce and data protection and prior associations with Amnesty International and United Nations, Bhumika brings a strong policy and global perspective to today's discussion. One of the Moving on to the next speaker, one of the key speakers for today's webinar is Mr. Aniket Ghosh, partner at King Stubb and Kasiva. He is a competition and regulatory lawyer with over a decade of experience advising on merger control, behavioral proceedings, litigation, dawn raids, compliance, and policy strategy. Aniket has handled complex high-stakes matters across various sectors including aviation, technology, private equity, among others, and appears before Competition Commission of India and CLAT High Courts and Supreme Court of India. Next up, we have Dr. Drishti Parnami, fellow at CUTS International for Regulation and Competition. She is a legal academician and researcher specializing in competition law and technology regulation with a PhD from reputed NLU Delhi focusing on AI in e-commerce sector from a competition law perspective. Dr. Drishti has experience across academics, policy research, and litigation, and is actively engaged in interdisciplinary research on digital markets, AI, and competition law. Now, uh, the speakers, now I will be presenting a brief presentation for setting context for today's discussion. I request Ghazal to please share the presentation. Yes. Now, uh, I will be giving a brief presentation on topics to be discussed for the webinar for context setting purpose. Today's webinar will mainly focus on digital platforms. Digital platforms are no longer passive marketplaces. In India, they function as core infrastructure for commerce, communication, and services, whether it is shopping, mobility, news, or messaging. Platforms increasingly determine how markets are accessed and experienced. What has changed fundamentally is the role of AI. AI systems now shape visibility, pricing, consumer choice at a larger scale. These are not just peripheral functions, they directly influence how market outcomes and competitive dynamics in the market. As a result, competition law and regulation are facing a turning point. The key question is no longer whether platforms are powerful, but how AI-driven decisions makes or reshapes what we call transparency, fairness, and market contestability in the market. Moving on to the next slide, platform evolution. We are currently witnessing an evolution where platforms are shifting from being a neutral intermediaries to gatekeepers. To understand this shift, we need to look at how these platforms are evolved. Platforms today are powered by AI-driven personalization, behavioral profiling, and carefully designed interfaces. These allow platforms to predict not only preferences but also steer choices and control user journey. When combined with network effects, these have access to vast database which transforms platforms from intermediaries to gatekeepers. Importantly, it is important to note that dominance here is not always exercised through exclusionary contracts or pricing decisions, but deliberately through these design and algorithmic choices. This is where AI incorporation is playing a key role. AI is not inherently anti-competitive. In fact, it delivers substantial efficiencies. It not only enables dynamic pricing, targeted advertising, better demand forecasting, and improved matching between consumers and products. These benefits can enhance our customer welfare and lower our transaction costs. However, as much as they help the market with the performance, they also pose some competition risk as well. Personalized pricing can lead to discrimination. Algorithmic systems can unintentionally coordinate prices across firms, and advantages can create an entry barrier for firms that are new to the market. This dynamics creates a tension where AI on one hand is enhancing efficiency, on the other hand, it is deepening asymmetries in the digital market. Regulators are now increasingly recognizing this tension. Can you please move on to the next slide? Uh, right, thank you. Now, uh, regulators are shifting this tension. Instead of focusing only on the explicit conduct, there is a shift towards an effect-based harm. Algorithmic opacity, dark pattern practices, and consent architecture are now central to these regulatory concerns. The understanding is that harm may not arise from a single abusive act, but from how digital systems are structured and optimized. This represents a move away from ex post enforcement towards anticipatory and structural scrutiny. And on this note, CCI has already begun addressing these concerns with the first step marked by market study on AI. The study acknowledges that AI can amplify both pro-competitive efficiencies and exclusionary risks. It has identified concerns such as self-preferencing, data-driven foreclosures, entry barriers, and algorithmic collusions. Crucially, CCI has also emphasized how transparency and accountability are necessary safeguards in AI-driven markets, where the most important suggestion that was given was self-regulation. This signals an important shift in competition enforcement. Traditional tools can no longer be translated onto algorithm-related markets or digital markets for that fact. These, these markets are now shaping into a new outcome. Now, this has also been observed in enforcement practice as well. In the recent Meta WhatsApp order, we see how CCI is operationalizing these principles. By examining data processes and data sharing practices through a competition lens, the Commission has now recognized that algorithmic systems and data integration can not only reinforce market power but also have an exclusionary or exploitative conduct in the market. One of the key takeaways from the judgment was that privacy and data practices can have direct and tangible effect on competition. The CCI acknowledged this how data is collected, combined, leveraged, and can even strengthen market power and influence competitive conditions, where conduct it itself does not fit in the traditional categories. Moving on to the next slide, similar logic are now being applied in dark patterns, such as forced consent mechanisms or misleading choice architecture. These practices are increasingly viewed not merely as consumer protection concern but also as competition issues because they distort consumer choice, accelerate data accumulation, and also reinforce the platform dominance. The broader lesson that we emerges here is that data, design, competition are now very deeply interconnected, and data accumulation cannot be seen in isolation. Moving on to the next slide, why why this webinar matters. We aim to examine how AI-enabled pricing, profiling, design practices affect the competition, how dark patterns can be assessed under competition law lens, and how data protection and competition frameworks increasingly overlap over each other. Our objective is not to restrain innovation, but to align innovation with market fairness and user trust. With that, I conclude my presentation. Thank you all for listening. I hope the presentation was informative. Let's start with the panel discussion now. Passing the stage over to the moderator now.
Thank you,
Hi,
Vidhi.
Vidhi. Vidhi, thank you. I would just like to take a minute, Bhumika. We
Yeah.
are also joined by Mr. Kailash Chauhan, who is chairperson of the AI Development Committee at ISAIL and a technical law researcher with the Intellectual Property Division at the High Court of Judicature at Delhi. And his work lies at the intersection of artificial intelligence, law, and intellectual property, bringing valuable technical and legal insight for today's discussion. I welcome you, Kailash, for this webinar today as a speaker. And now I would request Bhumika to please take over. Thank you.
Thank you, Bhavika. Thank you, Vidhi, for setting the context so wonderfully and giving the detailed presentation. Uh, Without wasting much time, I would directly, go to our first speaker, that is Aniket. So, Aniket, we had the CCS market study that came exactly almost 2 months ago, and the study extensively went into the pro-competitive effects of AI, like personalized pricing and how it was leading to better efficiencies and better outcomes for consumers across all sectors. Some of the sectors the CCI looked at included e-commerce, retail, marketing, healthcare, right? But there was also certain concerns around what AI could lead to in terms of algorithmic collusion. Now, when we talk about algorithmic collusion, it's often very difficult to determine whether it's facilitated by human, whether there's intent, or whether it was something that the AI and the algorithms themselves sort of facilitated the conduct without the human in the loop. So, Aniket, to sort of better understand how we see algorithmic collusion in context of competition law, what are some of the challenges that may come up when competition authorities around the globe sort of try to tackle algorithmic collusion related concerns. So, what are some of those challenges that we are sort of going to see and we are seeing currently?
Thank you, Bhumika. Thank you, CIRC, also for that wonderful introduction as well. Uh, I'd like to immediately get to the response to the question without wasting too much time. So I completely understand. I agree with you that now the biggest question that is in everyone's mind is how is algorithmic collusion going to be determined? Because, like you rightly put it, there is a absence, particularly when it comes to algorithms, there is an absence of intent. And so, from that perspective, it is when you talk of collusion, one of the fundamental requirements is that there has to be some form of agreement. That is the requirement under Section 3.3 of the Competition Act also. But in fact, the lack of an agreement was in fact one of the reasons why prior cases against the airline companies on their pricing was one of the reasons, the fact that it was an algorithm that sets the prices in between the airlines was a reason why liability was not found against any of the companies. But now with this market study, I think it is gives us a very big signal that the CCI is no longer looking at the traditional form of intent that we have thought of. In fact, what the way the CCI is looking at is how in one of the recent events that I had attended, the chairperson was very clear in her position where she said that whoever has made the tool or whoever has deployed the tool, from our perspective, we are going to look at whether the enterprise concerned that is deploying the AI tool, have they put in place the necessary self-audit checks in order to ensure that there are no collusive outcomes that come from it in terms of pricing or such and such. So now, what does that mean practically, right? So of course, regulator has said we are going to look at it based on whoever has deployed it, whoever is, signed off on that, they would be liable. But how do you actually look at it? And that also the CCI has given a good guidance in the market study guidance notes itself. And one of the things that we the code obviously we are not going to look at the codes that are part of the AI because nobody's going to sit and examine that. What we look at is basically three major themes, I would say. One is that what is the objective of that AI tool? What is the model objective? Is it optimizing demand? Is it optimizing cost? What is is it trying to undercut somebody? What is the overall objective that this AI tool is looking at? So that is one thing to monitor. The second thing is that what are the type of data that is being fed for that particular tool to operate in? Is it only the first party data, or is it using data scraped from rivals or shared common vendor platforms? If it is of the latter, then it can raise concerns of algorithm collusion. If it is of the former, then of course, you know that it is only using my own data. So again, that risk factor from the tracking, from the data aspect is another area to look at. The third thing that the guidance note has also identified and helped us and has given some form of guidance is the market patterns as such. What are the ultimate outcomes? Is the outcome resulting in a consistent trend of comparative pricing, the same kind of pricing that is coming across? Is the prices that is set by one company due to a tool matching what another rival is also doing, or is it following? Are we seeing that kind of a fact pattern also emerge? These are the three core themes that will have to be looked at. So it's not, of course, that you're going to go and sit and now audit the codes that the AI tool is using. But these broader checks can be undertaken at an enterprise level from a compliance perspective. So while, of course, we are not going to be, I mean, I don't think that we are looking at abandoning the concept of intent completely, but these form of these patterns will be looked at by the CCI, is what I understand from the market study, and will be inferred to determine whether there has been some form of collusion or not. So that is essentially where we are probably gonna see a lot more sort of action from the CCI perspective. And that's what we'll have to probably see. So, I mean, which is why the CCI's guidance on having structured AI impact and self audits become very, very relevant, because these checks can be done in-house and checks can be done in order to prevent any tool sort of crossing over into anti-competitive territory. So that's how I'd probably respond to that.
I think that makes sense, seeing the whole conduct from three point of view: objective, data, and market outcomes. But Aniket, when you talk about how CCI might move forward even when intent is not there, right? So are we talking about situating the conduct within the existing competition law, or do you see any need for further tweaks to the act, or is it sufficient to take care of these kind of situations?
Now, the situation is that this is a challenge that has actually been spoken of quite a bit, that whether or not Section 3.3, when you talk of agreement, does how important is the requirement of intent, right? But the fact is that an agreement under the Act is quite widely defined. And to my opinion, uh, I think that the way the definition of agreement proceeds, it's sufficiently broad enough to also include any form of practice that can become that can be anti-competitive in nature. So from that perspective, I think the existing framework does have the capacity to sort of take into consideration these kind of practices as well that may come about through AI tools.
Certainly. I think another thing that will most probably require is more capacity for the CCI to now implement it, as we were discussing earlier, whether we
True,
talk in terms of technical capacity or financial or personal capacity.
true,
Thanks,
absolutely.
Aniket. Thank you, Aniket. Moving on to Drishti. Drishti, when we talk about algorithmic collusion, we also sort of look at other AI-driven conduct, right? Like AI-driven personalized pricing. Now, these conducts might not be anti-competitive per se. It may have positive outcomes in terms of better efficiencies, better results for consumers. So, how do you see this thin line where this personalized AI-driven personalized pricing crosses into the realm of violation of any competition law? And how do you see the competition authority taking adequate steps to sort of work on it?
Thank you so much, Bhumika, for this question. And so, in this regard, see, personalized pricing definitely, as you mentioned, that it has pro-competitive effects. However, we can also not negate that the fact that it has certain anti-competitive effects as well. So for example, when you talk about personalized pricing, so it is basically every consumer's willingness to pay is separately calculated on the basis of several factors that includes maybe geography, the income status, the devices that I am using, my browsing history, etc., etc., etc. So the n number of factors which is being taken into consideration while calculating each consumer's willingness to pay, right? Now here what can happen is that I'm just discussing the anti-competitive effect or the abusive effect of personalized pricing, that it may lead to predatory pricing, it may lead to algorithmic collusion, in a secondary manner, and somewhere it can lead to market foreclosure as well because of the data loop. So I'll just explain these points very briefly, step by step. So when we talk about predatory pricing, so with the help of the technology, any platform can actually divide the consumers into two categories, one with higher willingness to pay and one with lower willingness to pay. So they can charge a higher price from one set of consumers and a lower price from other set of consumers. So ultimately the losses which they are incurring because of charging a lower price from a set of consumers, they can immediately recoup that losses by from another set of consumers, right? So this is a new age predatory pricing issues that might arise in future. So this is one of the issues that regulators might need to be little vigilant about. Here what we can do is we can have a lot of consumer surveys, what actually consumer awareness is also required in this regard, what the consumers want and whether they are comfortable with this kind of setup or not. So for that, market study specifically addressing consumers and small businesses should also be one of the idea that I think a regulator should think and move forward their idea with. Second is see with personalized pricing, lot of data is collected now. With the with for a technology, for an AI tool to run better, you need lot of data. So it's a feedback loop. So better the data, better the technology will work, better the technology will work, the better the services any platform would be able to provide, the services will be better, more customers will be attracted towards the platform, thus bringing in more data. So anyway, with personalized pricing, any platform could have the capacity to have a good database and create a network effect and be a dominant entity. So this is another anti-competitive or abusive issue that might arise with respect to personalized pricing. Definitely it has pro-competitive effect as well, but I would say that rule of reason approach needs to be little followed in this aspect, and we need to be vigilant. At CIRC, we have recently submitted a study to our study in this regard to OECD as well. It's in the process of publication. We'll share it as soon as it get published among. So we have covered the issue of refusal to deal, price discrimination, self preferencing, and how dominant entities should and the regulators can manage all these issues in detail. Yeah.
Thank you, Drishti. I think there's definitely need for more consumer surveys, and that's one section that the market study also did not look at and missed out on. How consumers sort of behave to these personalized recommendations. Do they see it as more meaningfully, or do they see it as limiting consumer choices? I think that's something that we need to sort of talk about in more detail. And Kailash, coming on to you, as we talk about consumer choices and consumer perception, I think we cannot miss talking about dark patterns. Like that's even sort of encoding small patterns within the UI UX of the system to push consumer to make a certain choice. How do you sort of view it as from a competition lens? Because this is something that has been purely being treated from a consumer lens, that something being sort of addressed by consumer authorities other than a topic which is being addressed by or seen by competition authorities. So, do you see any scope of interference or intervention by competition authorities here, or what kind of interventions do you require or do you see meaningful to address concerns arising from dark patterns?
Hello, everyone. I would like to say that generally we have two approaches. First is the early intervention approach, and the other one is the to wait for clear evidence for market foreclosure and then take the action according to the assessing the harm caused. So as per my view, I would say that instead of taking a specific direction or choosing one of the two approach, I believe India or the with respect to this issue, we should take a balancing approach. Uh, let's say the what exactly the law says that with respect to the two approaches, the Competition Act under Section 3 and Section 3, which talk about the anti-competitive practices, and the Section 4, which talk about the abuse of dominant position. So reading in Section 3, which specifically use the likely word, that means the Section 4 of the Competition Act prohibit the abuse of dominance, including the unfair condition or the denial of market access, even if its effect is likely rather than proven, allowing the proactive scrutiny of algorithm collusion under the Section 3 subclause 3 of the Act and the Section 3 subclause 4 of the Act for vertical restraint like the exclusive launches. So if we talk about the practices by the Competition Commission of India, there is a case, it's called the Delhi Vyapar Mahasangh versus Flipkart. It's 2022 matter in which the court has accepted the early intervention approach. Obviously, we should have the option to wait for the clear evidence in the second option, but it was been in practices in this matter where the CCI found that the Flipkart, which was the platform, was in platform colluding with the Samsung and Xiaomi by giving them exclusive launches and algorithm favoring and the preferred listing. And the court, the CCI has held that this is causing foreclosure, and it was held liable under the Section 3(4) of the Competition Act. So I believe the favoring of the early intervention approach, especially where the platform is dominant and they are dealing with the data and the involving the data and algorithm are a relevant factor. As discussed by the Aniket, the AI market study of the CCI 2025, they have also warned about the self-learning algorithm establishing the tacit conclusion and that are undetectable later, that self-learning algorithm leading to the dishonest agreement and the platform colluding. So I believe waiting for a clear evidence of market foreclosure and consumer harm also align with the act itself under the Section 19(3), that weighing the factors like barrier to entry and the consumer benefit before deeming the appreciable adverse effect.
Kailash, are you there?
I don't think he's here. Maybe connection issue.
Okay. Maybe Ghazal or whether you can check with Kailash if he can join back again. Okay, I think he's joining back again. In the meantime, Aniket, I'll come to you. Kailash was talking about whether to take early intervention approach, whether to wait and watch it out, or whether sort of taking interventions in network effects market where it doesn't take time for markets to scale up and scales to tilt, right? So I would sort of like to understand from you what is your opinion about the approach that we should sort of go ahead with in AI markets, where we are currently seeing a lot of innovation, especially from smaller players, smaller startups coming up. But we are also seeing concerns, maybe not so much in India, but in other countries, we are seeing concerns around how AI might lead to certain anti-competitive conduct, right? So I would sort of like to understand from you, where do you see, which approach do you see India adopting going forward?
Personally, I think my point is that I feel that this is an area which requires a very subtle amount of uh, supervision. I don't think that we are at a stage where there's a requirement for us to really go ham and tongs behind companies using AI tools. I mean, like the EU has an AI Act now altogether. So I don't really agree with that sort of an approach because, as the market study also notes, there are three, most of our businesses essentially are AI models which are built on existing Gen AI infrastructure. So from that perspective, I don't think that we really need to intervene over there. The concern comes where, of course, is in the other layers, which is the infrastructure layer, which is the data systems that are required, the data centers, which is, of course, operated by the big tech companies. The other concern is, of course, on the actual data annotation for the building of the AI models itself, which are again, these are concerns that are that are being discussed abroad as well. Now, to my mind, I think CCI as a regulator, what the better option I personally think is that we adopt more of a light touch sort of system right now, particularly because most of our models or the apps or the tools that we are seeing in India are based on Gen AI models itself. And more of policy support mechanisms, like, for example, the India AI mission is trying to do policy support mechanism to support startups in, say, the infrastructure and in the main data layer, which is the actual model creation layer. Though that's where I think our interventions should probably be. So, from a regulator standpoint, I think it should be a very light touch sort of a format at present. But that's at least what I believe. And I think to that extent, I also anticipate that the government is also aligned on this front because in certain remarks of the MeitY secretary had mentioned in one of these conferences, he had mentioned that they are not very keen on, adding too much of regulatory compliances and checklists for companies that are using AI tools at present in India, as they would rather want to put in more supportive measures for building up startups at the compute stage, startups in the in the infrastructure related stage. So that's where I think I have a feeling that the government is also sort of aligned on this approach.
Thank you, Aniket. No, I think that makes sense. And in the meantime, it might work to sort of keep working towards building capacity, doing more market studies to sort of understand the markets better, whether it's AI or whether it's dark patterns, to sort of continue with those soft advocacy mechanisms. And you talked about self-audit, and I think Kailash, you were also earlier talking about a balancing approach. So, Kailash, I would sort of love to hear your inputs on the self-audit guidelines, not the guidelines, but sort of the note that the CCI came up with in the market study itself, right? So, what were some of the sort of pros and sort of hits and misses that you saw in the self-audit framework?
I believe there should also be given an importance to the other approach, which I would say the first to analyze the harm rather than strictly sticking to the uh, strictly sticking to the early approach, because uh, being a lawyer and a researcher in the High Court, I believe the there are a lot of issues in most of the sector in India where the law is there, but the implementation and the execution, when it's come to the implementation execution, there is a lot of issue involved. So because of this reason, I would say early intervention might create a should not be create a act as a barrier for the for the data-driven economy, because our data-driven economy is being a large part of the GDP, especially post 2025. In 2025, the share of the data-driven economy in the GDP was around like 30%, which was in 2022 it was 6 to 7%, and it is going to be become like around more than 20% in 2030. So even a small, because at the early intervention stages we don't have a specific evidence, we are just working on a prima facie basis. So any intervention or any regulation should not act as a barrier in this sector, because it's going to create, it would then create a lot of problem for the even for the MSME sector or the small players. So that's my take on the study of the CCI 2025 official market study which they have released.
Thanks, Kailash. Drishti, coming on to you on that note, something that we earlier talked about was, apportioning liability and sort of allocating liability. And something that you also talked about was how AI practices like even AI personalized pricing might tilt towards anti-competitive conduct, right? Now, often the people who are sort of building these algorithms are developers are coders who might not be aware of the competition principles itself, right? They might just see it as a little tweak to the algorithm to improve consumer efficiency, might then cross the threshold and turn into something that might sort of attract CCI's scrutiny, right? So where do you sort of see the need for educating technical developers more on the competition compliance principle side?
See, Bhumika, any coder or the developer will not work in isolation, right? There will be a team. Whenever such kind of tools will be developed, it will. I think Aniket also mentioned, and we were educated in that recent event which me and Aniket both attended. That see, we have to before launching any kind of software, there should be a testing, a black box testing, right? I mean, in the what does black box texting means that testing means that what will be the possible outcomes of that particular algorithm or that particular AI tool on the markets or any particular segment of the society. It should be clearly tested, and then only after the clearance of all the regulators, be it the competition regulator, be it the data privacy regulator, or any other related regulator, only after the clear testing, it should be available to the in the market. Otherwise it will be very difficult. Once a AI tool is launched, there will be no way we can detect it, we can control it, and we can undo it. So as regulators, it is very necessary that we have to be very careful from the beginning itself, because these markets, this technology is dynamic in nature, and considering the lack of capacity all the regulators have in the country, we do not have that. So once the ship is sailed, it will be very difficult to bring it back. So my idea, again, as far as everybody is talking about self regulation, I have to little comment on that as well. Self regulation, I think it's a easy option, it is a feasible option, but say suppose I mean, I have a little doubt on that particular point, is that will big tech self regulate? And even if they do, how do we know that they are regulating, self regulating? I mean, do we have the capacity to even check that whether they are doing self regulation or not? So I mean, all these questions, as an academician, it really worries me, because I mean, how do we need to have some technical know-how and some data to understand the self-regulation part as well. So yeah, this is my concern.
No, I think that raises an interesting point. The need for sandbox testing, of course, which is also something that is being practiced by other regulators, including SEBI, right? But also when it comes to mechanisms like self-regulation. And Kailash, again, here I would like to sort of bring you in because this is something that you were talking about earlier. So how do we, although self-regulation is meant to be more of voluntary and not something that has to be mandatorily supervised, but as Drishti said, that there are challenges with the self-regulatory mechanism also because companies again then might not comply. So how do you sort of see India bridging this gap between self-regulatory mechanisms, but also ensuring that the systems are sort of going through necessary checks before they are being implemented or deployed across different sectors?
See, I believe taking a balancing approach. I mean to say that there should be a case to case based scenario. The regulating authority should take a case to case based approach, because in near future the major market player, it's already this digital economy or data driven economy, always there are dominant player. Multinational companies are there. India means the domestic companies like Reliance is there, and the or the let's say any other platform like the new startup which are coming up like Blinkit, Eternal, and the other e-commerce platform. There is a lot of ability to implement or to misuse the self-regulating mechanism. So as I earlier told that in the future there are going to be a lot of development in the AI sector, which is going to make them more, I would say, capable to misuse misuse in this domain. As the Drishti has earlier told that about the study, that there is a lot of tactics which this multinational company might use. So in this situation near future, this is going to be more challenging area. So where where the picture is clear that the player which is in question has a clear ability to be a dominant player and has a ability to use the data or the experience in the relevant other market where they have ownership in the other market as well. So in this situation, I would say there should be a scrutiny and it should not be totally left on the self-regulating mechanism. Thanks.
Thanks, Kailash. Coming on to you, Aniket, we discussed a lot about the CCI's role in sort of the evolving AI ecosystem that we are currently seeing, right? But what I would sort of like to understand from you is, since data has become, one of the key parameters now, and we are consistently seeing sort of overlaps with some of the domains that might come under data protection regulators authority, right? And this is something that you have worked on before as well, being the part of the meta case. So I would sort of like to understand from you, hear from you that where does CCI draw the line when, especially when it's engaging with data practices? Is it just limited to recognizing data as a competitive asset, and when does it sort of end up becoming a de facto data regulator? So sort of would love to hear from you on that.
Thank you. But before I answer that question, I should lay out that whatever I say is entirely based on everything from the public domain, and there's nothing from my previous engagement that I'm speaking on. So I just had to make that clarification out. But either way, I think see, data, to my mind, I think, of course, see, data is definitely an asset, but provided that data can, but simply having data is not necessarily an asset. And some of that is, I think somewhere that sort of understanding is lost in the current discussions on how to regulate big tech and all of that. Because, I mean, you may have a lot of data, but if you don't provide an innovative product, you're not really going to stay relevant. And in fact, that's exactly what we saw with, if you may have seen in the US, you had the Google Chrome, the search and the Chrome dispute that was taking place. And ultimately, on the remedies, the judge actually noted the fact that, AI tools have actually become a big competitive constraint to Google search. And therefore, the whole idea of, breaking up Google and selling off Chrome, which is what the regulators in the US wanted, that was ultimately dismissed, that particular plea. So from that perspective, I think um, this is I feel this is not really spoken of as much in the sense that data alone is not really a competitive um, thing. I mean, a facet or an aspect. It's actually what you do with that, which is what's important. And therefore, innovation is actually what makes these companies where they are, to my mind. Um, and at the same time, of course, the CCI, in its current foray with this whole case and all of that, I think there are a couple of things that the CCI perhaps should have looked into a little more carefully. One is, of course, like I don't think there was enough analysis on how that data collection or the consent practice that was being deployed by the concerned company in that case, whether it was raising the difficulty for rivals to also onboard them, number one. Does it make it difficult for rivals to or consumers to multi-home or to switch? And so these sort of aspects is something that should also be part of the analysis when you are looking into any data related harm that is sort of being alleged. So I think that is sort of an area where the CCI should, or that is where the CCI should also keep a checklist in mind. Otherwise, there's a big risk that, uh, pure play data protection related questions can suddenly just become a competition law question. And I think that is not what the act also aims, and I'm sure the CCI also doesn't want to look at it like that. And so I think number one, what is the impact on, say, rivals and their costs in acquisition of those users' data? Is that data collection practice so intrusive that it is preventing users from switching over or being able to being able to probably be onboarded with other platforms? So that is something that really needs to be focused on. Like, what is the actual impact of that data collection practice? Simply the fact that it is okay, you have only a yes and no choice. That should not, to my mind, be a factor for a pure play competition law analysis. And I think that's where we are seeing a little bit of if I might say, the CCI also taking a slightly more aggressive stance, if I might just say it at that. But yes, so I think that's what is the most important point, because we can't have simply the use of aggressive data collection as an anti-competitive harm. I mean, and there has to also be some competitive impact, and that is what the CCI should really be looking into. So that's what I think is the interplay over here.
Thanks, Aniket. I think that's a very nuanced understanding of it, and some of the things that CCI would have to be sort of mindful going ahead when tackling with questions of data. I see that we are sort of nearing towards the end of the webinar and moving towards the Q&A session. So before moving on to sort of Q&A session, I would quickly like to come to each of you for your closing remarks, sort of summing up whatever insights you are sort of taking along with you, and any remarks that you would sort of want to add on to the whole discussion. So, Drishti, over to you.
Before giving my closing remarks, I have, I think, one question from Aniket. I mean, just the previous discussion that you had. I mean, you were saying that even if a company, even if a platform has a lot of data and they're not applying technology on it, I mean, there's no use of that data. Am I right? Yeah. So my question to you is, that do you think that data and technology are two separate things, or they are so interlinked that you cannot separate them? So if you have a good technology but not the data, to process, that technology on. And if you have good data but not the technology, so I mean, how are you actually separating these two things? According to me, they are very much interlinked and cannot in any way be, separated. So I mean,
Okay, happy to answer that. So what I was basically trying to imply is, you have a lot of these instances where companies who have perhaps been at the pinnacle because of the amount of data that they've had, just because you've had a rival who's come up with a better product, has sort of, surpassed them. Like as a simple example, you have I mean, currently, let's take the current example that I mentioned. Google search becoming constrained by AI search models like the ChatGPT or Perplexity and things like that. Comet itself, in fact, launched by Perplexity, is another novel tool which they are sort of integrating their AI as an entire part of their search engine. So from that perspective, Google search is becoming a less and less it's something that people are not using as much as perhaps people were doing 5 to 10 years before. So what I mean by that is that while of course Google has a lot of data, as do a lot of the various companies, but if you are a company that is able to provide a very relevant product, um, you will end up succeeding from a competition standpoint in the market. Like the rise of TikTok is another very classic example. I mean, the way they just, because of the fact that they were offering an excellent product, a lot of social networking sites and social media platforms, including say Facebook for that matter, they sort of saw lesser engagement from users just because of the fact that you were providing a good quality product. So that's what I mean. That while, of course, data is important, I'm not saying that it's not, but the fact that people have data or big tech has data is not really a sufficient parameter, to my mind, for conclusively determining, or at least determining that they are prima facie dominant in any situation. I feel there are a lot of competitive constraints that innovative uh, products can have on companies that may have a lot of data as well. So that's essentially what I was trying to say.
Okay. Thank you for your response.
Yeah.
No, thank you, Aniket. I think I also sort of agree with what Aniket said. We used to have Orkut and Yahoo at one point that used to dominate the fields, but now we see other players that have come up. So it's all about who has the better product, whose product is more efficient, more sort of tailored to consumer needs, who is able to understand consumer in a bit more nuanced manner. I think it all comes down to that. And so you might have all the data, good quality data in the world, but if you don't have a solid product or something that sort of caters to a gap that currently exists in the market, you would not be able to do a lot with that data. Completely with you, Aniket, on that point. But yeah, Aniket, on that note, would sort of love to hear your closing remarks and then move on to other panelists. Yes.
Yeah, I think uh, as closing remarks, I think this is quite an interesting session where quite of important points did come about, particularly so I think there are three themes, right? One is, of course, your AI tools. The second is, of course, the point on data as market power. And third is, of course, on the consent architectures and all of that we were speaking of. Now, from the first point, I think the AI tools itself, I think we're probably going to see a lot more as more and more businesses onboard AI tools. It will be important for them to start having in place, like Drikshi very rightly pointed out, having in place sandboxes wherein these tools can be at least audited and the necessary documentation be kept in place by companies before they deploy such tools, particularly from the competition law standpoint. Because like Drishti mentioned, when deployed, you don't know when they might just cross barriers and they may just dip over to the anti-competitive side. So I think that's a major takeaway, which I think all companies and businesses should really start sort of thinking along those lines. Apart from that, I think the aspect of having regular self-assessments, which I think Kailash had also highlighted too. I think those, when it comes to self-assessments, again, it's important to also have not add to the compliance burdens of the companies, but at the same time, we need to find a fine balance on how to go about that. Because see, like Kailash said, that rightly we are a digital economy. I mean, it's a reality, and every other aspect of our economy is now determined by digital companies. So from that perspective, I think it's very important to have light touch sort of checks on what are the tools that you're using, how is your consent architectures designed, what are the frameworks that you have in place, because that's where I think self-assessments are going to become very important. So I think bottom line, for a company standpoint, self-assessment is going to be the key. From a regulatory standpoint, also, I think that a light touch mechanism is, I think, what we are probably going to see going forward, unless there are, very specific conducts that get highlighted to the commission. But I also anticipate that there will be more capacity building and sort of collaborative coordination with various other agencies that will probably take place. So that's essentially, I think, where my 2 cents would be on all these points that we discussed. So yeah, thanks.
Thanks, Aniket. Drishti, over to you.
I think Aniket have mentioned almost everything that we have discussed and all the key takeaways. But however, I would like to say that competition. The beauty of competition law is that it, in some or the other way, in most of the cases, will overlap with other sectors. If it is, say, suppose if the issue is of petroleum, then petroleum board will be involved. For electricity, electricity board will be involved, and for telecom, TRI is involved. Then consumer law, and then privacy. It can never work in isolation. So in some or the other way, you cannot put a straight jacket formula ki, oh, this is pure competition law matter, this is a pure consumer law matter. All these are, it's a gray area. So earlier the jurisdictional conflict was solved by courts, and that, okay, this particular 1 2 3 points will be dealt by TRI, then this will be dealt by CCI. But considering the kind of markets that we are discussing, the AI driven markets run by AI, and the data, and the speed and velocity is the primary concern. The market is so dynamic that we cannot just wait for the courts to decide the jurisdictional clearance and work. Then here the only solution that comes to my mind is to work in collaboration. All the regulators, whatever the case is, we have to all collaborate and fight this, and and solve this matter. I mean, now the time is not to solve the jurisdictional conflict. Here it is, now is the time to work in collaboration with whatever the authorities, whoever are concerned is. So this is my first point, which I feel that it should. And second is, yeah, CCI has done a first step on AI market study and competition. It's a commendable step. However, I still feel that more empirical studies need to be conducted. The study is good. They have given a very clear version of what is AI, what are the AI markets, tax of AI, which I was not aware. But still, we got a very clear picture of that. However, I still feel there are several other sectors that were not covered. Then there were, I think, MSMEs, consumers, and there are several other stakeholders that need to be actually we need empirical study, and that too at a grassroots level. We do not want studies only urban elite members should be the part of that study. It because the real consumer lies in tier 2, tier 3, and the villages as well. So the study should not cover just one sector. Every segment of society should be involved in that particular, because the matter is not just it's not just about competition, it is about privacy as well. They are taking our data, they are taking our people's data, so they should be aware and involved in this particular new age challenges that we are facing. Yeah.
Thank you, Drishti. I think greater collaboration, just not across authorities, but also across different stakeholder groups, would be crucial, with especially the technical community while developing any policy. I think that's the key to bring all stakeholders within the loop, to consult them, to understand the nuances that are behind these technologies, because even developers themselves are sort of understanding these technologies as they go forward. Every day we see some new innovation that comes up. So for regulators and policymakers to understand these sort of more coordinated effort with technical community would be very crucial, so I believe. Kailash, coming on to you, what would be your sort of closing remarks for this webinar?
Yeah, first I would just put add on the Drishti's point that being a researcher, I believe that there is a huge lack in the interdisciplinary research in India. I was doing a research in few years ago in the which was a interdisciplinary between competition, patent law, which is IPR, and the economy. So I was not able to find the research paper which specifically written to keeping in mind the or they are written on the data taken from the or empirical data taken from the Indian market. Most of the research I have to cite from the other markets. So definitely that would create an error even in my research. So I would definitely say that there is a huge need for the interdisciplinary research between the ministries itself, like CCI and the MIT from the data point, and the DPIIT from the IPR perspective, and the from economy perspective between the commerce department. Such study are crucial to at least to taken a clear picture or to know exactly what the position is with respect to India. And finally, I would say that the leaving the innovation freedom entirely to the dominant player, or in other words, the blindly supporting the self regulation mechanism would, I would say, lead to the innovation, but to the in favor of the dominant players only, because they would only do the research, they would only get benefited by the self preferencing, and rather than keeping the market contestable. And I would say it is very important to keep the market contestable, because there are a lot of small players in India which called the MSME sector, which is growing. Like I was doing a research few years ago in 2020, where I just found that the MSME sector in India has a contribute 29 to 30% in Indian GDP, whereas in the US, which is more than 50% and nearly 60% in the China. This might be little bit changed now because it is a few 5 years earlier study. So there is a lot of room for the MSME sector to grow from going from 29 or 30% to the equal to the Chinese or the US level. So having a contestable market would give a opportunity for this smaller player to participate fairly in the digital economy or data driven economy, I would say. So that's my remarks. Thank you.
Thank you, Kailash. It has been an interesting webinar. I would now sort of open the floor to any questions that we might have for any of the speakers. I think maybe questions can be put in chat, or maybe you can raise your hands, and maybe Bhavika and Vidhi might help with unmuting and having some questions.
I cannot see the option to raise my hand. Can I just proceed with my question?
Okay, Rahul, I think since you're already on unmute, please go ahead with your question and to whom you are sort of addressing that.
Okay. Thank you. First of all, I'd like to thank Cuts and CIRC for organizing this wonderful and opportune webinar. Although we do have Section 49, but such attempts are always commendable. From Aniket sir's presentation, I got a new sort of point of view that simply having data is not sufficient. You need to have the means to utilize that data, commercially exploit that data. So I am a believer that of all the remedies suggested regarding AI and big tech and competition law, data interoperability is one of the most feasible long-term solutions. So my question is specifically, if data simply is of no use, if sharing the data is of no use, then does that make data interoperability a less viable solution, or what may be the additional challenges? And from Drishti ma'am, I'd like to sort of, she advocated for self-regulation, but I'm a bit skeptical on that. That how how much can we rely on self-regulation? Where do we draw the line when self-regulation and self-preferencing become indistinguishable? So I hope my questions made sense.
I think, Aniket, over to you. On the second question, I'm not sure if Drishti was in the favor of self-regulation, but I think we'll come on to that later. Aniket, yeah, moving to you on the first question.
Thank you, Rahul, for the question. So, okay, I'm not saying that data is not valuable. At no point do I believe that it is not at all of value. And if an enterprise has invested money in the collection of data through legitimate means by virtue of, just by virtue of giving access to a particular service, and for that it is collecting some data, I don't think that uh, that is not valuable, right? But the point that I wanted to mainly make is that on the point of interoperability. Now, while of course interoperability is definitely um, helpful and it is required, it is beneficial for consumers. Particularly, we've seen that happen in the UPI apps system, because we have a public digital infrastructure, and in that, of course, we are seeing the benefits to users from that. But from a competition law standpoint, where the problem does, to my mind, come in when we're discussing data, is that purely seeing data as a barrier or as the collection of excessive data or a lot of data is not at all a complete scenario. What is necessary is that you need to necessarily have those innovative models and tools that you have in place. Now, on data interoperability, my view is that, see, if it is something which, again, on this, I may feel that I'm generally a person who believes in lesser intervention. So even if it is an innovative technology, I feel that at the end of the day, innovation does end up taking care of a lot of the challenges that we see, because a player that is, say, a very large player, say 20 years ago, may not necessarily be so today. So from that perspective, I don't necessarily believe that data interoperability is uh, a right approach, particularly when we're dealing with AI tools, because we are at a very nascent and initial stages of this particular technology, and I think it's important that regulatory interventions should not uh, come in the middle of that right now. Perhaps as the technology matures a little bit more, I feel that at that stage, maybe, say, interventions might be possible of having, say, data interoperability requirements and mandates like that. But I don't personally think that is particularly, because we are also a developing economy. I mean, that's another thing that we should keep in mind. And we would like more and more businesses to succeed in our country. Unlike, say, Europe. Europe, for example, they have, under the Digital Markets Act, you have the data interoperability as a mandatory requirement for digital gatekeepers. Now, to my mind, I think that is not really beneficial in terms of, I mean, it may be beneficial to some extent, but I don't personally see, without the necessary surveys, without the necessary empirical data to support that there is an actual impact on and harm that's happening to competition, an actual impact on harm that's happening to consumers. I don't think that there's a need for the intervention to take place on data interoperability mandates at present. So that's my essential view on this point.
Thank you, sir. That clears my doubt.
Thanks,
Yeah.
Aniket. Moving on to Drishti for the second question on how self-regulation can not work out and the challenges associated with it.
First of all, I'm sorry, Rahul, I have never mentioned that that self-regulation is a good idea. In fact, I was talking against it. I mean, I was talking in a manner that see, self-regulation definitely have its own problem first. That how do we know that big techs are self-regulating? Do we have the capacity to know and to understand? And why would big techs self-regulate? So basically, I raised these 2 points and not otherwise.
Sorry,
Yeah.
ma'am, I missed your point previously. Thank you.
I think there's one question in the chat. I'll just read it out. What challenges arise in balancing privacy protections under the DPDP Act with AI data collection practices while also ensuring fair competition under competition law? I don't
Bhumika, would you
see.
like to answer this question? I believe the audience would like to hear your opinions as well.
Definitely. I think this is something that Aniket also talked about earlier, the challenges. And this is also something that we recently saw within the Meta case when data related practices or concerns come up in the market, then where does the CCI actually step in? So, as of now, there are certain overlaps between the DPDP Act and how AI data processing might happen in terms of companies are increasingly relying on scraping of data to train their AI models right now. What kind of data is these models being trained on? Is it sensitive personal data or non-sensitive personal data? Of course, then the contours of law would be different for each of these kinds of data. Secondly, we sort of had DPDP rules also come in, which talks about certain data collecting practices. And I think Aniket would be able to talk about this in much more detail. But as how I see it currently, the DPDP Act is sort of adequate to address the concerns that come up in terms of AI data collection practices, since a lot of safeguards around consent, around meaningful consent, are already built in within the DPDP Act, and it's something that is sort of constantly. Companies are also, as they move on, as they sort of go ahead with developing new technologies, they are also sort of seeing what kind of obligations they might fall. They might fall sort of accountable to. Aniket, would you sort of like to come in and talk about challenges that you see, particularly in context of overlaps with DPDP and AI data collection practices?
Yeah, I think this is a very, topical point. One of the challenges, even if we separate out AI data collection practices, I think from a more general data collection by uh, so normally under the DPDP and under the erstwhile SDPI rules, you had consent. You had the option of withdrawing the service as a company to a person who's not providing your consent. What the decision in the WhatsApp Meta case and also the NCLAT case, what it does is that one of the factors for which these companies were found to have contravened the law was on the point that you are withdrawing access to the app if you're not accepting the 2021 privacy policy update. Now, the challenge, and this is, I think, was also argued in by the appellants in the case, was that, if that is what the data protection regime actually requires, that, if a person is not given the consent, you do withdraw access to the service, and you are entitled to, as a company, to do that. But under the competition framework, being a dominant player, uh, you are you will have to still provide the service, even if the person, or say a more not the complete service, but perhaps maybe say a beta version of the service or something of that form, if a person withdraws his consent. So there's a conflict as such directly on point on this as to when a dominant player, do they have additional obligations beyond the DPDP framework? And that's where the complication actually has arisen. And I'm not sure how the regulators are going to, or any other dominant enterprise or big tech enterprises are going to approach this, because under one framework, withdrawal of consent, withdrawal of service pursuant to a lack of consent is legitimate and is encouraged, in fact, and mandated, in fact, under the DPDP as well as under the erstwhile SDPI rules. But under the competition law framework, as a dominant player, I am still required to provide the service. And in fact, that's also, so that's something which we'll have to navigate now. And that's the biggest problem, I think, when in examining pure play data collection as a competition law harm. But then again, that's my personal take. And that's essentially where I think where the challenges is, one of the major challenges of this.
I think there's a follow-up question from Frenny. So she says that India proposes pay to train AI copyright law granting access for royalties, which essentially imposes a compulsory licensing regime to train AI. It fails to grant an opt-out mechanism, given that the CCI went after WhatsApp's privacy policy change for contravening the law and failing to offer an opt-out mechanism. Isn't the government's proposal similar as choice is taken away? Aniket, would you like to sort of answer that?
Hi, Frenny. I'm glad to see that you're in the audience. But I think there are two different takes on this. I think from a government point of view, of course, it's part of a policy perspective, and from that aspect, I mean, that's a policy decision that the government is taking. So the lack of a necessary opt-out may not really fall within the same framework with which the CCI examined the WhatsApp privacy policy. So from that perspective, I think they'll operate on two different frameworks. And rather the governmental regime, if it does come into picture, would probably be looked at from the constitutional standpoint, safeguard standpoint, rather than from the the competition law framework at all. So the frameworks would be quite different, and that's why the government is going ahead with it also.
Kailash, would you like to also take up this question, considering your expertise in IPR?
Yeah, I think I agree with the Aniket's view that this government's it's a research paper actually which talk about the royalties or the regulating the issue regarding the use of the data where the copyright or IP exists in the data. So in that cases there is a lot of issue. There are cases in the even New Delhi High Court filed by ANI against the OpenAI. And even globally there are a lot of matters going on. In India, it's the first matter where the issue is ANI told that their newspaper or their data or publication was being used to train the OpenAI's large language models. So it's an issue because there is no law in India to govern this, what to do, whether they can use it without the consent or they can take the consent first and then to use it. If they want to take the consent, what should be the term and condition? In EU, they have a EU AI Act. They have the regulation that there are options, the opt-out, if you want to opt out, if you don't want to opt out, or if you want to apply for the royalties. There is a whole mechanism. So this paper kind of tried to resolve this issue. But I think this approach given in this paper would not be applicable where the IP is not involved. That's what Aniket is saying in the competition matters, where IP is not involved. There, I don't think this would apply. Yeah, thanks.
Thank you, Kailash. If there are any more questions.
Sanchi, I think, raised her hand. Do you have any questions?
Yeah, I hope I'm audible.
Yeah.
Hi, everyone. My question is to Aniket because they answered a question just now with regard to what they think of innovation alongside competition. And they mentioned that, because being against a lot of interventionist approach, innovation is something that, if I'm understanding it correctly, potentially self-resolves issues of dominance. I'm unsure if my understanding of this is correct, but if it is, I would like to know more about this approach and how you look at it.
Oh, okay. Yeah. So, yeah, you're right about what I was. You framed the point correctly. The fact that I was basically the point I'm trying to make is that when you have, especially digital markets, you see a lot of frequent innovations being undertaken by companies across the board. You have different features being added on, different types of, I mean, if you look at the different updates that different app providers they come up with, there are so many and that take place in just a year. I mean, let's take, I think Zoom itself. I mean, to compete with Zoom, you have various other newer players. Like I think WhatsApp has also added some meeting mode and all those things. So from that perspective, what I'm trying to say is that, see, innovation is the cornerstone of the digital economy, and considering that to be the picture, uh, when it comes to AI, which itself is a major innovative product, it is a careful sort of intervention is required in this, if at all, particularly considering that we are also a developing economy. And a lot of our, we would like more business activities, more investment. And from that perspective, overreaching and adding on compliance burdens might discourage, smaller enterprises also ultimately to sort of, uh, take up those kind of steps. So from that perspective, having overarching regimes of, say, data interoperability, like having a blanket sort of a rule or that kind of system might not really work, given how fast moving and innovative this whole space is. So that's essentially what I was referring to, and that's where I'm coming from. I'm not saying that it always solves all dominance issues, or issues that any anti-competitive conducts arising because some players are dominant. But yes, just the simple fact of having a lot of data, in at least that I think is not necessarily a blanket idea that that company is going to be dominant. So
Right.
that conception, I think, is something that we need to talk about that a little bit more. And I think that aspect is not really talked about as much.
I think one
Understood.
example
Just
of how
one,
fast
sorry.
markets evolve, sorry, Tanshi, just adding on to what Aniket said, one recent example that we saw of how fast markets evolve, we can see in the recent US judgment, which came in the case of Meta's acquisition of Instagram, right?
Yeah.
When the case started, the regulator, the FTC's allegation was that the relevant market should comprise of social media apps, which are sort of used to communicate with your friends, your family, to post your pictures, right? That was the relevant market that the commission was leaning towards at that time. But over the years, as we have moved, the sort of the features of the Instagram itself has changed. And there was this one study done by a university in America to sort of understand for what purpose Instagram is being used for currently. And what they saw was that it's not to sort of communicate with your friends or family or to post pictures as much it is being used to see those short form reels, short form videos. And that then changes the definition of relevant market entirely. Now you are looking at different players, a different level of competitors that are present. Earlier, TikTok might not have made the cut as a player when the relevant markets definition was restricted to sort of networking with your family. But now, as it has evolved to sort of consumption of short form reels, it is one of the biggest players, right? So, and this has sort of happened over the last, 4 to 5 years. And so the point is basically that innovation sort of happens quite fast, and that sort of tilts and changes the way that we look at the markets, how they are sort of shaped, for what purpose they are being used. What might have been a key feature of a technology a few years ago might not even be a feature of the technology any longer, right? So as Aniket was saying, some of these issues are taken care of itself as and when technology changes, and innovation continues to come in. Smaller players, bigger players sort of come in and sort of improve their features, add new features to the technology. So yeah, if Aniket or Tanshi or anyone, if you have anything else to sort of add to this point or to the whole conversation, please feel free to sort of unmute your mics and jump into the
Yeah. I
conversation.
just wanted to follow up on this itself. And while I agree that like innovation is of course like a cornerstone to like most markets as a whole, but like specifically for digital markets, my question would be that it's probably like players who hold like the larger amount of data who are using it to innovate, for example, providing a more personalized experience on certain platforms by even if it means leveraging your data in certain ways, it probably is something that's catered to the user a lot more, which gives them that sort of experience where they prefer certain platforms a lot more. So in that sense, where then does intervention come in, and how do you envision intervention to be a lot more proportional when it comes to a market like a digital market, wherein innovation does go in hand with like the availability of data certain players have and the larger gatekeeping of the data also that these players are able to use within not just a specific market but also leverage on other markets.
I think one point that I would just like to clarify before Nikita, I sort of bring you in, or Drishti or Kailash, if you want to jump in. When we say digital markets, it's not a separate segment or separate sector that we are talking about. It's market as a whole, and how different sectors have incorporated or integrated technology within their working existing ecosystems, right? So even companies that used to be primarily offline, like Reliance, right, are now switching on to the more to an online version. So it's not that there's a distinction between online or offline, or treating digital market as a separate entity. Rather, it's market as a whole with two sides to it, with offline and online, which are often integrated. Aniket, if you would just want to come in on what Tanshi said, or if Drishti and Kailash, if you want to come in, and with that, we'll hopefully close the conversation for today.
Yeah, this is a topic which will, I think we can all keep debating on for hours.
Exactly.
But yes, it's a good question, Tanshi. I think so. What the kind of approach that typically should be looked at is pursuant to actual effects or likely effects, right? Now, that would, of course, require more empirical sort of examination, and that should be the way, to my mind at least, that should be how a regulator should approach these kind of sectors. That if I am intervening, I do have some form of basis to argue that okay, there are the accumulation of data is such that it has prevented anyone else from also accessing it. Like say user data. Now user data as such, I mean the data I provide to Zoom, I can provide to when I log in, my email ID, my name, etc. That can also be provided to others. Now, is it a data that is exclusive to a particular enterprise? What is the value of that data, and how much is that data being used to, say, increase a particular company's market share? So that examination has to be very precise. And I feel that unless you do that, there is a risk of perhaps overstepping the boundaries and sort of intervening where an intervention may not necessarily be required, and innovation would probably take care of any kind of harms. So that's how I would ideally like to probably frame it. Of course, that is not from a practical standpoint. Not every time a person, say a complainant, wants to approach the commission with a particular case, not everyone will have access to that. But then that's the job of the regulator to then ensure that they collect and get that sort of empirical evidence before making that kind of detailed interventions. So I think that harm aspect is something that's very crucial. Whether it is likely harm or even actual harm, both should probably be looked at. But it should not be without that facet in play. And otherwise, you can be you will end up entering into a space where your intervention might just cause more damage. And from that perspective, I think that's how I'd probably like to sort of balance it out. The effect is what would be very critical.
Thanks,
Yeah, thank you
Aniket.
so much.
I think with that, we have come to the end of the webinar, and it has been an interesting session full of insights around how algorithmic collusion, self-referencing, personalized pricing might be seen at, what would be the CCI's role moving forward, how do we define sort of digital markets, what is the role of data. So a bunch of themes that we managed to cover in such a short span of time. And it has been a pleasure sort of moderating this discussion. I hope we sort of continue these kinds of discussion offline within the chats, or whenever we sort of meet in person. Thanks to the audience for being patient and staying tuned with us until the end. Thanks, Aniket. Thanks, Kailash. Thanks, Rishti, for your sort of wonderful inputs. And thanks to the CIRC CIRC team and Kingster for organizing this webinar. I think with that, I would like to end the webinar. Thank you.